Hi, everybody. This is Jeff Baller with the Apartment Owners Association, and it is great to have you with us today. Beautiful day, and we are covering how to properly prepare and serve those rent increase notices. And specifically, this was just going to be in-person event in Alameda, but we expanded that out since we shifted online. There's over 100 additional people that have registered. And so I think we're going to be able to help a whole lot more people doing this one online. And anyway, so thank you for being flexible and shifting here with us. And AOA, again, we've been in business here for almost 50 years, and just so thankful to God, so thankful for all of you that are faithful members. And anyway, we just want to make sure you do things right. And so here we are talking about it. Before we do that, I do want to just mention AB 2042. It's something that the Judicial Committee is meeting today about it, and it is really crazy. I want to read what one attorney, what his take on it. He says it's pretty onerous for both landlords or housing providers and debt collectors. First, if passed, it will act as a strategic delay mechanism for tenants, especially um, in LA, and I wouldn't just say LA, but everywhere where the judges have never seen a motion to set aside a judgment that they don't like, and combined effect of the burden shift, the evidentiary hearing right. Anyway, he goes into it and he just says this is a total nightmare. Really, what it ends up doing, what they can do is even like a default, basically it's really about default judgments. And there could be a default judgment from a long time ago, up to even 15 years, that could be unraveled because the they could just say, I was never served. And then the onus is put on you to prove that you actually did serve them. And it's insane considering that they're giving so many other notices all the way through the whole eviction process. And anyway, so this is very deceptive in the original language. This is the cleanup bill for AB 747. And in that original bill, this language is in there. It was removed. And then this cleanup bill 2042, they put it back in. And so there's a lot of people that didn't even realize it was there. It's very, very sneaky. And anyway, so we have a campaign about this where we're asking you to call, asking you to make a public comment, and we have instructions about that um, on our website. If you go to PAC, Political Action Committee .aoausa.com, we have that there. If you're in LA County or LA City, they're looking at banning rubs. I know for some of those you're watching, and maybe you're even in San Jose where they have banned it already. It's another one. We have a campaign going about that as well, and we're asking you to call, leave public comment. So there's a few things. There's way more than that, but this video is really supposed to be about just coming up with a rent increase notice. So we will get into that. But we want to equip you. We want to make things easier and more enjoyable for you. And unfortunately, these laws work absolutely the opposite. So we want to advocate for you, but also empower you because, AOA is only as effective as the member base is active. And, just because we have the largest association in the state doesn't mean that we're listened to unless we have a lot of people behind us. Contacting and being active. So anyway, thank you for taking action. And you may have never ever taken action on anything before. I hope this is your first time because this one really, really would be just crazy. And we'll cover it at another time, but hopefully we won't have to cover it. Hopefully we'll kill it today and it'll be okay. So anyway, I don't know if you watched it, but we had a how to maximize your AOA membership course that is online on our YouTube channel, AOA USA. I want to welcome some of you, our brand new members. You're watching for the first time and you're watching from our website. Just want you to know this is recorded, and there's a whole lot of other ones that are on the AOA USA channel on YouTube. And then also the ones that there are certain things that we do, seminars that we do in person that are recorded. Those are in you have to log into your membership account to be able to access those. So that's exclusive content for members, and there's some really good ones there as well. And anyway, so we had a San Diego, we had some stuff in LA in person, and man, we'd really love to see you there in person May 26th. So this is coming up next week. We plan on being in Buena Park, and we're going to cover how to fill out that lease agreement if you're in Orange County. And then May 27th, how to fill out that lease agreement if you're in the San Gabriel Valley and not under rent control. And anyway, so we're kind of wrapping up the seminar season over the summer. You guys take a break, and so we don't meet, and then we'll get back to it in August with the AOA Million Dollar Trade Show and a few other things. And we have some live streams all day long, or not all day long, all week long. So tomorrow, we're going to be covering the same topic, but it's going to be more for the state of California and San Jose. So that'll be tomorrow, same time. And then on Thursday, we have yet another live stream, and that's about Prop 13 in the battle over property taxes, and that'll be with John Kupal, who's the president of Howard Jarvis Taxpayers Association. And the next week after that, we already have 1,000 people registered for it. June 4th, how to handle problem tenants, and June 18th, smart tax strategies. And that's not related to selling, but that's just in your operations. So that one, it should be really good. And again, we're just trying to help you save money any way that we can. And why pay Uncle Sam if you don't have to, right? So our speaker today is so finally we're going to get into this thing. Our speaker today is a Bay Area real estate attorney representing property owners and housing providers in landlord-tenant matters, litigation, and owner disputes. He helps clients navigate California's complex rent control and eviction laws. And before getting into this space, he represented Fortune 500 companies as a commercial litigator. And so it's really a pleasure. Prit, you have a special place in our heart. And I hope, yeah. So anyway, I want to welcome you and give you the floor here.
Thank you so much, Jeff. Can everybody hear me properly?
Yeah, you're great.
Okay, great. Well, thanks for informing us. We're at 2042. It almost seems like it, defeats the purpose of a summary proceeding, but that's just my opinion. So looking forward to the campaign against that. Today we're going to talk about rent increase notices, as Jeff just mentioned. How to prepare them and how to serve them. I think both are important. We're just going to go through what kinds of notices you can serve and what the hierarchy is. I'm going to introduce this thing that I call the hierarchy that I think everybody should go through when serving a notice to increase rent. And so this is governed by Section 827. A lot of you probably heard of this section. I'm just going to break it down a little more, and at the end we'll know exactly what to do when we want to increase rent and how to serve that notice and how the state views this and how the local cities, and then whether or not AB 1482, which is the Tenant Protection Act, affects any of this. So the first thing I want to start off with is just my basic rule, which is going to apply throughout this presentation. And that basic rule is anything that's 10% or more, 10% or below, in terms of increase, calls for a 30-day notice. If you want to increase your rent and the rent is going to be more than 10%, the increase, then you need a 30-day notice. Anything that is above 10% needs a 90-day notice. And we'll see how, this is modified depending on whether you are governed by local rent control or the Tenant Protection Act, or if you're exempt from everything. This equation is going to be calculated a little bit differently. So the first thing we want to do, I call it a three-step process, is we want to look to see if the property is governed by rent control, aka is there a rent control ordinance that is in your city? Cities like San Francisco, Berkeley, Oakland, these are rent-controlled cities, as we all know, and they're going to have their own rules as to how much you can actually increase. They are allowed to completely set aside the state law. Again, state law tells us 10% or below is 30 days, more than 10% is 90 days. And then state law also tells us if the Tenant Protection Act applies, then the rules are a little bit different. And then, exempt properties is that exact rule that I mentioned, 10% or below, 30 days, above 10%, 90 days. Let's first talk about the local rent control laws. So as I mentioned, the city ordinances, they completely overrule regional state caps. And one thing that a lot of landlords, are upset about is that the ceiling or the caps are very different. The ceilings are ultra low, and for cities like San Francisco, Berkeley, and Oakland, like I said, this rent board is going to police this entire process, and they want to see exactly what you're increasing and what terms you are changing. Normally, if there is a month-to-month tenancy per state law, you can unilaterally change terms of the tenancy because you're on a month-to-month. So as long as you give 30-day notice, you would be able to unilaterally change the terms of the tenancy, which includes the amount of rent. And usually that means you don't need their permission. You don't need for them to sign a new agreement, sign a new lease. It's unilaterally changed by the landlord. When we enter city ordinances like San Francisco, Oakland, Berkeley, a lot of those rules are thrown out. So even though you're on a month-to-month tenancy, the only thing you can really change is the rent. And even with that, you have these really ultra low ceilings. For San Francisco, it's 1.6%, as an example. Oakland is 0.8, and Berkeley is at 1%. That is much lower than the state caps that you were giving outside of these ordinances. And the way that the equation that I introduced earlier, if it's under 10%, you do 30 days. If it's 10% or more, you do 90 days. Well, in this situation, it's impossible to serve a 90-day notice because your change in rent is always going to be below 10%. I mean, we're talking 1.6, 0.8, and 1.0. So it's really not possible for you to even serve a 90-day notice. It's always going to be a 30-day notice. And the local cities will tell you exactly what you can increase at. If it's 1%, if it's 2%, 3%, whatever it is, they'll let you know. But when you get into the state law territory, then it comes in two different flavors. One is if you are subject to the Tenant Protection Act, which a lot of people know as AB 1482, or if you're exempt from that. If you are subject to that, then your equation is a little bit different. It's 5% plus local CPI. And local CPI means Consumer Price Index, and you can find that out on the internet by going to the bls.gov, and I believe Department of well, I don't want to misquote here, but let's just stick with BLS. You can get these metrics from them. It's 5% plus local CPI, but no more than 10%. So a 90-day notice here is also an impossibility because, again, 10% is max, so you cannot go beyond 10%. That means for rent-controlled cities and for non-rent controlled cities that are subject to the Tenant Protection Act, you're always going to serve a 30-day notice under Section 827. And then we get to exempt properties. These are properties that are, again, that are not subject to any local rent control by the city or sometimes even the county. And they're not subject to the Tenant Protection Act because it's a newer building, it's a single family home owned by an owner, not a company, an LLC, or a corporation. We're not going to really go through the Tenant Protection Act in detail, but if it is exempt, then your equation is 10% or less, 30-day notice, greater than 10%, 90-day notice. And here, you're not really capped at anything. You can increase beyond what the TPA allows, and you can certainly increase beyond what the local ordinances allow. And so that's really in situations where you have a city like Fremont that is subject to state law and it doesn't have a rental ordinance. You cannot use it in a city like Hayward or really any city that has an ordinance. So those are the three types of procedures that you use when serving these notices. But the next step is you want to make sure that you have these notices drafted properly. AOA has a excellent Form 102 for 30-day notices, and I believe Form 106 for 90-day notices. What you want to do is you want to make sure that you have precise information in these notices. And what I mean by that is I've given examples of these in the past at prior seminars when we discussed termination notices and pitfalls and things like that. What I constantly say is you want to make sure that you have all the descriptions in the notice precise. You want to make sure you have the right address. You want to make sure you have the right building number. If it's avenue, write avenue, don't write street. You also want to make sure that you have the right names. Every occupant that's there, you want to list them there, and you don't want to use shorthand, things like the Smith family or the Gonzalez residence. You want to name each occupant individually if they're above 18. You want to make sure that these notices are, again, they're precise. And I just like to use the word flawless just because landlords are really under the gun to have these things as precise as they can. So you want to make sure that these notices are basically flawless. And again, starting with the names and the address is a start, but you also want to make sure that you avoid typos. Not just on the tenant names, but you want to make sure that the citations and any legal language that you quote from those citations is also precise. You don't want to, have a comma missing or a word missing if you're quoting something. And a lot of times we do quote the statutes and these codes directly. When you look at the notices, I don't know if any of you have actually looked at the AOA Form 102, but one thing that a lot of landlords fail to keep in mind is that you have to give 30 days. And sometimes, as obvious as that sounds, people do that incorrectly. So they'll go ahead and state that starting, for example, July 1st, your rent is going to be blank. Again, depending on whether you're subject to city ordinances or state law, you will calculate that amount. If it's subject to the TPA, you will do you'll figure out the CPI index, and you're not going to go beyond what the cap is. Once you figure that out, You also want to make sure that you give the right amount of days. So if you put in your notice that the rent is going to change starting July 1st, but you mailed out that letter, or sorry, you mailed out the notice or you served it on June 5th, that's an invalid notice at that point. Why? Because it didn't give the tenant the entire 30 days. So you want to make sure that that date is, or if the date is July 1st, then you give that 30-day gap. So you serve that notice on June 1st or whatever that date is, that will create a full 30-day gap. And so if you don't do that, then again, you have a defective notice and you cannot increase your rent for July 1st. You have to serve a new notice and you have to start all over for August. So you want to keep that in mind. You also want to make sure that your dollar amount is precise, right? You want to make sure that you list every single amount. You want to list the beginning rent, or the initial rent, and you want to list what the new rent is going to be. A lot of landlords will just say your rent has increased to blank, but they're not going to specify what the rent was before. So you want to make sure that you put both of those figures, what they paid before and what they're going to pay after the increase. And that goes for security deposits as well. Landlords are able to seek higher rent, but they're also able to seek a increased security deposit. And the same thing applies to other changes. So it's section 827 doesn't necessarily limit you to increase the rent. You can increase other provisions in your lease, such as when the rent is due, what the grace period is going to be like, what the pet policy is, these kinds of things. And again, anything that involves material terms other than rent increase in city ordinances, you can't really do anything. All you can do is increase the rent. You can't increase other provisions, even if you are on a month-to-month lease, unless they sign off on it or they sign on a new lease. So those three things you want to make sure you have. You want to make sure you have the right dollar amounts. You want to make sure you have the before payment, rent payment, and the after rent payment. And you want to make sure the same is true with all other changes. If you're changing the pet policy, you list what the policy was before and then what it's going to be after, for example, July 1st. Just so they have a clear comparison of what the terms were before and what the terms are going to be after. So once you have that ironed out, you want to make sure that you are serving this properly. And this becomes a little bit tricky because service rules, I think, are probably the most confusing rules that we have in landlord-tenant practice. In a general civil litigation case, you're really subject to one statute, one way of serving documents. When you serve a lawsuit, you have a specific code, state code that you're adhering to. But when you're evicting, when you're starting an eviction case, you have at least two statutes that you're dealing with here. And the third statute, I would say, is 827, because they all have different rules. When you're serving a termination notice, you're subject to a certain set of rules, service rules. And when you're serving the actual lawsuit after that termination notice expires, then you are subject to other rules, which is the typical civil litigation rules that apply to all civil cases. For substituted service, the rules are different. For personal delivery, the rules are different. And for post and mail, they're different. When we're serving a notice to change terms or a notice to increase the rent, we really have two choices. Technically, we have three. We can either choose personal delivery, we can choose substituted service, or we can choose post and mail. And when you see the AOA form, you'll see that those methods are actually included in there. But when you are dealing with a residential tenancy or a commercial tenancy that involves a qualified commercial tenant, we're not going to get into that, but most of you landlords are dealing with residential properties. And in that situation, you can only serve these notices either by personal delivery, personally handing it to them, or by mailing it to them. And this is where things get a little bit tricky. When you're personally serving, uh, you don't have to add additional days. And this is sort of the hidden rule that I'll talk about in a bit. When you personally serve this notice, let's say you serve it on June 1. If you serve it on June 1, you simply just wait 30 days. And when you get to day 31, that's when that notice takes effect. So that's when the new rent or the new term kicks in. But if you're mailing it, then you have to add 5 additional days. So it really becomes a 35-day notice. And you do that because when you're mailing, the state law says anytime we mail anything, if we're serving by mail, we have to add 5 days for it to actually arrive to their mailbox. And generally, it takes less than 5 days. I'd say things are normal with the U.S. Post Office. But 5 days is what you're supposed to add on. So in this situation, let's say you mailed the notice on June 1st. Well, it can't, your notice can't say that we are seeking to increase the rent effective July 1st. Why? Because you're not giving that 35 days. It all comes back to that rule I mentioned earlier, is it doesn't end up becoming 30 full days because again, if you didn't add those 5 days, then it didn't account for the time that it would have taken for that notice to arrive in their mailbox. So when you're serving this notice, you want to make sure that you either personally serve, and if you're mail serving, you add 5 days. And if you don't add the 5 days, again, it will be an invalid notice. So if you go on that way and you collect additional rent, then you might be subject to penalties, and we don't want any of that to happen. Then we get to the proof of service, the actual form itself. Like I said, the AOA includes that form with the Form 102. And you just fill that out, or your process server fills out their own. But a few things you want to keep in mind. Some of these are obvious, but you want to make sure that the server, sometimes it's the landlord or the landlord's agent, whoever is serving that must be 18 years of age or older. And they're not a party to, they're not a party to this proceeding, or they're not involved in this in any way. Now, the landlord could do this, and the landlord certainly is involved, but that is one exception that exists. The landlord cannot serve lawsuits, but they can serve these notices. So you want to just keep these things in mind. One thing that a lot of landlords do not consider, even though the AOA provides the proof of service form in the change in terms form, you want to make sure that you don't actually serve the proof of service on the tenants when you're serving the notice, because what that presumes is that you prepared this proof of service ahead of time. So the proof of service, and all proofs of service have a little declaration in the end that say, you certify that under penalty of perjury that you served this document on this date, either by personal service or by mailing it. If you're doing personal service, then you want to make sure that the notice is, that the tenant is only getting the notice, because the idea is that you will then fill out the proof of service after you have served them. and you will hold that for your records. Otherwise, if you fill out a proof of service ahead of time that says you've personally served this tenant on a certain day, well, then you're technically committing perjury because you haven't done that yet. So when you're mailing out, then you can go ahead and do that because, again, it's going to take 5 days for them to receive it, and they would have known. So you want to make sure you keep these things in mind. Um, The other thing I want to go through is just really the history of UDs, and I think it all ties into a lot of this stuff. Is UDs are supposed to be summary proceedings, and there is a trade-off that the legislature introduced 150 years ago, which basically says that. We're going to allow summary proceedings. We'll allow these quick 2, 3 month proceedings because landlords shouldn't have to wait a really long time to get relief because they have to pay mortgages and things like that, and they need rent. But the trade-off was that every single notice that you serve, be it a termination notice, be it the UD complaint, it includes these things like the 827 notice to change terms or to change the rent amount. It applies to these as well, which means we have to have these things perfect. They need to spell out the names properly. They need to have the right provisions. They need to have the right waiting periods, calculated, and you need to make sure that you serve these properly. Any mistake that you make in these could call for not only waste of time, but damages that the tenant could pursue against you. And a lot of these damages include treble damages, which simply just means any damages that they are entitled to seek, you multiply it by three. And so these things become serious, and these penalties and these damages, all these things add up. And time is also money, so you want to make sure you have all these notices proper. I think the best way to do that right now would probably just use AOA's form, whether you're using a 90-day notice or a 60-day notice, because it has the proper blanks and it has the proper language in there. And I don't think you'd go wrong using any of those forms. Again, you're allowed to use whichever form you want, but it's always good to use something that's been tried and tested. And a lot of the AOA forms, I would say, most of them are tried and tested, and they've been reviewed by attorneys and they've been reviewed by other legal professionals as well. And so that's the summary of my presentation. I mean, this wasn't a very complex statute, but it is fatal nonetheless if it's done improperly. And anytime you do serve these notices, you can serve them as a landlord, or you can have an attorney, prepare and serve them for you. But like I said, you just want to make sure you have all these. You make a list of all these things and just check them off. Do I have the proper ordinance? Do I have the proper parties? Do I have all the names correct? Did I serve this properly? Is my process server 18 years of age or more? You follow all these steps and we use AOA's notice, I think you should be fine. But just keep in mind that everything is scrutinized against the landlord, and everything that the landlord does is viewed very, very with hyper focus, I would say. And it's almost like landlords are not allowed to make mistakes, but tenants are. Um, so with that in mind, if anybody has any questions, I'd be happy to answer them. But this is it for my presentation. Anybody has any questions? I'm all ears.
Great. Yeah, if you're watching in the Zoom meeting, you can go ahead and raise your hand, and then I'll ask you to unmute yourself, and you can go ahead and turn your video on and ask your question. So you can do that if you're watching on YouTube. you can put your question into the chat and they'll get that over to me and we'll be able to take that. And we just updated. So guys, production guys, I'm gonna ask you to share the screen that I share here real quick, just as people are kind of gathering their questions. I do want to say that we just came out with the, so guys, if you could share my screen. Yeah, we just came out with the new maximum allowable rent increases under AB 1482 or the Tenant Protection Act of California, or AKA statewide rent control. So here they are, and you'll see that, yeah, this is for this year and next year. This takes effect, uh, what is this? August 1st. So this is your last chance to give a rent increase notice for July, because starting in August, the rates change. And for most of the places, and I'll do Alameda County, look at the difference there. 24, 25, it was 3.8%. CPI was 3.8%. This year it's 1.3. So you want to get your rent increase now because you'll get 8.8% maximum, versus if you wait till August, it's going to be only 6.3% that you can get on that. And so this is Alameda, Marin, Contra Costa, San Francisco, San Mateo. If you're not in there, if your county is not in there, then you will know that you're lumped into all other California counties, unless you're watching and you're not from the Bay Area, like there's LA and Orange County, Riverside, San Bernardino, Ontario counties, San Diego County. So this is all mapped out, and we hope that you use this as a guide to make sure you get your increases right. And we want you to get, so the timing on this is definitely intentional, and we want you to get the best increase that you can, just because that's important. So I'll stop sharing that. And one of the questions, okay, we have a couple things in the chat. One of the questions that we get this a lot, Britt. If I have a single family home or a condo and I haven't given them the notice saying that this is exempt from statewide rent control, but I haven't actually ever given a rent increase at all since statewide rent control went into effect, what do I do at that point? What would the person do to be able to raise the rent?
We actually deal with this all the time.
Yeah,
The answer to
yeah,
that question is you simply serve them a TPA exemption notice. And we have a few templates as well, but either you have that in your lease agreement when they initially contracted with you, and a lot of landlords don't do that, but you want to make sure that you do serve that TPA exemption notice before you serve any of these notices, because that is a grounds for a dismissal if this ever turns into a UD. And the period for that is also 30 days. So it does add a little bit of time, but
that's
you want to
good.
make sure you serve that. You wait the 30 days, and that notice is served in the exact same manner as what we've just discussed. If you're mailing it, you add the 5 days. If you're personally serving it, you can do it that way as well. And you want to give them minimum 30 days. After
Mhm.
the 30 days, you can go ahead and proceed with whatever it is that you want to do with, whether it's a rent increase, or if you want to serve a 30-day notice or a 60-day notice on them to terminate their tenancy. You want to basically do that after you served your TPA notice.
Right. So that TPA notice, we have it, Frit's office, they have it there. And so that's really, really key. And this is the difference. If you don't serve that notice, you're subject to that chart that I just gave you. You got a single family home, you're subject to the multifamily rule. So you're basically taking property rights away from yourself because you just didn't do the paperwork. So I only say that I know a lot of you online that are watching, your members, your multifamily, but a lot of you actually have a mix. And so I just want to make sure you have the full thing, that you get your full property rights because you can raise it to market level. You could be, I talked to a guy yesterday, he inherited a property. They never raised the rent. Rent was $850 and market rate was $3,000. He can raise it all. If he does his notices correctly, he can raise it up to $3,000. He can raise it to market, even though his parents never did that, he could do that, but he's got to follow the right sequence and make sure the place is habitable. You can always ask your renters, hey, is there anything that needs to be fixed? I know you might think you're opening a can of worms, but it's better to just be safe and create that goodwill and see, are they just asking for marble flooring or is there like a serious issue that needs to be fixed? And, if you're asking, I think it's helpful. So I do have a question here from Joe. He says, how do you raise your hand? And so if you actually hover on the screen, you'll see some icons, and in the middle there's a raised hand icon. And so yeah, Joe, if you would be able to raise your hand right there like that, and then we can get to your question. And I have so many different screens here. I need to find all my stuff, but I'll go ahead. Joe, you did ask. Let's see, you don't have your hand up yet.
There's a question here from Joe.
Yeah, I see his question though. So I have a tenant ghosting me after I served notice to raise the rent. Been very unresponsive until I served this notice. Not sure how to proceed.
Yeah, for to answer this question, I'll use the word could instead of should. If I say should, they'll be giving legal advice. So the answer to that question is, well, and that does happen, is they won't even respond. But at that point, assuming that your notice was proper, your waiting time was proper, it was properly served, then their rent is different. So if it's increased, 10% or whatever that amount is, and they still send you the prior, amounts, then that is not the right amount. And so that will be subject to a notice to pay or quit because you're not going to accept a lower rent amount. You're going to accept what is under contract. So after you serve that notice and they ghost you and they're still giving you the old rent, well, after 3 days, you can technically serve a notice to pay or quit. And I guess if that doesn't get their attention, then I don't know what will.
All right. Okay, next one from Jeff. My earlier understanding was that at the end of the first year of a 1-year lease, it required a 30-day advance notice of rent increase, but after the second year, a 60 days notice was required for rent increases on a year lease increases. So the second part is incorrect. The 60-day part, that he was under the assumption it's a 60-day notice for rent increase.
No, that's correct.
What's correct?
So if a tenant's lived there less than a year, then it calls for a 30-day note. Well, it's a 30-day notice to vacate. And if they've lived in more than a year, then it's a 60-day notice to vacate. But the thing is, that's a termination notice, so that is correct, but
Okay,
it doesn't apply to
the rent increase.
change
Okay.
in terms notices.
Okay. Yeah. So that was it. You just confused the
Yeah,
termination notice with the rent increase
yeah.
notice.
No, it's what you're saying is, Jeff, is correct. It's a different statute. So we're not terminating anybody's tenancy. We're just saying, hey, we're changing the terms of the tenancy. Either we're changing the rent or we're changing some other provision.
Okay. Got it. Okay. And so Joe, he still doesn't see it.
Can you hear me?
Yeah, I
We
can
can
hear
hear
you.
you, yes.
Is
Okay.
that you, Joe?
Yeah.
Okay, great. Go for it.
I got a video. Okay, so at any rate, I have a friend who is a broker and a real estate agent. He gave me the appropriate paperwork. His main point to me was just to get the tenant to serve or be served with a new rental agreement because he wanted the notice of exemption, which was the property is not subject to the rent limits imposed by section 1947-12 of the civil code, which
Right,
would give me more protection.
right. And that's the Tenant Protection Act.
So
The AB 1482 was codified into the statute that you mentioned. Um, that's also another way to go about it. But it's not required to propose another lease agreement if it's a month-to-month tenancy. You can unilaterally make these changes to the tenancy. And I think what he said was let's give them a new lease that has the TPA exemption in it. But like Jeff and I just discussed earlier, you don't necessarily have to have it in your lease. A lot of people forget to do it, as long as you serve them a standalone TPA exemption notice. So you can serve them the notice, and then you can then serve them the change in terms of tenancy to increase the rent. And both of these documents will be unilateral, meaning you're not seeking permission here. But with the route that your broker recommended, then you technically are seeking their permission if you're asking them to sign another lease.
Yeah.
So
So Joe, it's great. Like you go for that route. You could go for route number one. We even did a video on how to fill out the AOA lease agreement. We did that online where we go through every single box. You can look at that one and you can use the AOA move-in packet. There's a bunch of different addenda that go with that lease agreement, and then you can offer it to them. But in the event that they are not willing to sign it, that's when you could just give them the notice that, hey, this is like what we were talking about. This is not subject, or this is exempt from statewide rent control, which would give you back your as much property rights as you could possibly have on that single family home or that condo. Does that
right.
right.
I started this process back in December and wanted to raise the rent 5%, which was allowable for San Leandro. But he pushed back. So I went from $175 and conceded and said, okay, I'll raise the rent 3.1%, which is $100 exactly.
So then this changes everything, right?
Yep.
Because he's already had a rent increase, so that doesn't.
No, he never had rent. We talked about it. He never got it. I never.
Oh, you didn't give it to him. Okay.
No. We talked verbally, but never was given. Then
Okay.
I proceeded probably a month and a half later, once I got the forms from my agent, served those. Probably we sent an email, we sent a text response, and he never gave us anything. So 2 months ago, that was all sent. It was a week and a half ago, I physically handed his roommate or cousin the paperwork. So I'm almost feeling like I might need to start over getting what's TPA stand for?
Tenant Protection Act.
Okay, Tenant Protection Act. But I feel like I need to start over with all the forms, but I am very thorough, like you said, names, dates, spelling, making sure all the I's are dotted, T's are crossed. I served that paperwork and I said, hey, it's been now a couple weeks. I'd like to get the lease back. And I was advised to give 90 days heads up about rent just to be safe. Then I have my neighbor who is a real estate agent and property manager. She said to join your group, which I did this morning, jump on this phone call to see how to proceed.
Cool.
So that's what I've done. Signed up this morning, jumped on the call. I don't want to make any mistakes. And my other friend told me, be very cordial. He had one client have him seek legal action saying he was being too aggressive toward the tenant. I've been nothing but kind and have fixed all items. And we've never raised the rent. They were $40,000 in the hole due to COVID when I had to pay all that money. And we've got past all that. But we're under market value and we've never raised the rent in 6 years. So we said, okay, $100 we feel is fair after we got shot down at 175.
Fred,
So
I'll let you take it.
yeah. So should I go with the original contract, which did have the provision in it? And if he doesn't sign it, I'm not sure how to proceed. I need to go over and ask, physically knock on the door and say, I need to get the lease back because my insurance is requesting a new lease. Then I can say, you still have not provided rental insurance, which my insurance wants to make sure the tenant has. And I'd like to double check and do a walkthrough on fire alarms.
Gotcha.
That's the whole case. So I'm not sure if I should stick with the one I've given him already or go back to your guys' forms and redo it and start over.
Yeah, well, I'll leave my information with you. Specific information like that, again, it's going to call for some legal advice. But basically, if you're, and if I heard you correctly, if your original lease had the TPA exemption provision in there,
It does.
which it does,
Oh, you're good.
you should be fine.
Not the original one, the one I just gave him.
Oh, sorry, the one you gave him.
Yeah, because
Yeah,
my buddy is like, we need
again,
to
so
get
there's
this
no ordinance in San Leandro yet. I think they're still working on it. It's gonna take
January 1.
it's gonna take into effect
January
January
1.
1. So
Yeah.
what I would do is, again, I without getting into details on what your insurance company requires or doesn't require, I would just simply not give the tenant any power, and I would just do unilateral notices, 30 days and 30 days. It'll take 60 days, but I would just do that and proceed that way. I wouldn't want to offer them new paperwork for them to sign. I would simply just do a 30-day TPA exemption notice, wait 30 days. When that expires, I would then send the change in terms of tenancy, let that expire, and then all that kicks in on the 61st day.
Right. And I just was under the impression if you gave a rent increase, but to just so not regarding to Joe, but if you do give a rent increase without having given the proper notices that it is exempt from statewide rent control, are you kind of stuck in being subject to it after that point because you gave a rent increase without having done that? That's kind of how that's how I've heard it. But I don't know that that's right. So can you either fix me or?
No, generally just means whichever notice that you tried to serve is not going to take effect.
Okay.
Oh,
And
so you're saying I have to do, number one, I have to do a 30-day TPA exemption.
right.
And then after 30 days, I have to do a change in tenancy.
Change in terms.
Yeah.
Oh, change in term.
Yes.
And then after I do that, if they do not accept that on day 61, I would give a 3-day quit or pay. Or
Right, because if they're offering you rent less than what's contracted to per those notices, then you don't accept that smaller rent. You then either ask them to give you the right amount, and you do that after you serve a 3-day notice. They'll have 3 days to give you that updated payment. And if they don't do that, then technically you have a cause of action for a UD based on non-payment.
And if they try to give you the old rent amount, you don't have to take it. You
Right.
say we're just only going to take a full payment. We're not taking partial payments. But I do see Rose, our beloved Rose. She has her hand raised.
Good
So
deal.
let's go to, thank you, Joe. We'll go to Rose, and if you could unmute yourself, Rose, we'll get your question here. And then Joe, if you could mute. Yeah, perfect. Thanks, Joe.
Okay, can you hear me?
Yes, ma'am.
Yes.
Okay, quick question. I kind of got in a little late and I apologize for that. So you may have mentioned this and I didn't see it. or hear it. But I just did a rent increase for Section 8, literally, and I got my paperwork like just 5 minutes ago. And so they did give me my rent increases of 5.1 and 5.5.
Okay.
But one of the things that I had to do was there was a piece of paper that I did an addendum to the lease because of the AB 1482. That I had to have that wording to prove to them that I addended the lease because of that. Is that normal? Or if I have someone else who is not on Section 8, would I have to do that as well?
I'm not sure what language did you include in the addendum?
I included in the addendum, and I don't have it right in my face. I'm so sorry. But while I'm talking to you, let me see if I can pull it up. What I included in, no, I don't have it. What I included in the addendum was the wording that comes from the AB 1482.
Okay. So the
And
exemption.
so I included that as an addendum, and then I had the tenant sign and date it
And this was an addendum to what?
to their lease. I'm sorry.
Okay.
To their lease, because there has to be certain wording in the lease now that deals with, or either with Section 8, that deals with AB 1482, because before Section 8 had no limitations.
Right, right. I probably have to look into that. I'm not sure how to answer that question, but as far as sending just notices, well, not leases, but notices to the tenants, they don't really require special addendums, but I could be wrong and I could look into that, but I'm not.
Or maybe I did the addendum because they said they needed proof that I had told the tenant about the Senate Bill 1482, because like I said before, in Section 8, it was never a given. It was never needed. And so now they do, because before they didn't have rent increases. And then what about like the city of Oakland? Because my understanding with the city of Oakland, you can't go over whatever that inflation amount is. And it's like some random number, like 0.08,
Yeah.
0.008 or something like that.
Right. Well, rent-controlled cities are going to trump state law, and 5% plus CPI. That's a rule for properties that are subject to the Tenant Protection Act. And if they're exempt from that, then it's you can go beyond 10% as long as you give them 60-day notice. For Oakland, I believe you can't go over 0.8%.
Yeah,
So.
something like that.
So these increases are not going to apply, um, to cities like San Francisco, Oakland, and Berkeley.
Okay, yeah, because that's what I was saying when you were saying that. I was like, I don't think that we can do that in Oakland. I don't think it works that way.
No, you're
Unless,
right. You can't do it in Oakland. And so in the beginning of the presentation, we
mhm.
divided them up by, three. So rent-controlled cities like Oakland, they have a different multiplier.
Yeah. Hmm.
Uh, and then
Okay.
TPA subject properties are treated differently, and then those that are exempt from that are treated differently.
Okay. Cool. Cool.
Yeah.
Cool.
Yeah.
Cool. What was I gonna say? There was something I was gonna say about it in Oakland, but just so that everyone knows that in Oakland, the housing authority, the feds trump both it trumped both the city and the state, but they have now at the federal level decided that they're going to abide with the state.
Hmm.
So I was able to get a 5.1 and a 5.9 rent increase.
Oh, okay.
Okay.
Yeah. Well, that's great. Thank you for the question, Rose. Really appreciate you. And then just hit mute. And I think that, let me see. Yeah, I think that answers the questions today. And we're going to have the exact same, it's going to be the exact same thing for San Jose tomorrow. And anyway, so you could tune in tomorrow if you'd like. And again, don't forget about going to the PAC website, pac.aoausa.com to get the directions on how to got the link there for you to leave a public comment, or you can, and then just the content, what to even copy and paste and put in there. That one's important for all of us, because if those are unraveled from 15 years ago, but then also moving forward, even if you have someone do that work for you, like, are they even going to be alive to stand in the courtroom 15 years from now, or in business? Are you going to be able to find them or not? And proving things could be difficult. So remember that, and definitely start taking pictures whenever you if you're going to serve it and you post it on the door, like take a picture of it, get all the evidence you can. One other question I had for you was just about, I know things changed right around Christmas time. The way the US Postal Service is postmarking things changed. And so I was curious if you had any litigation around that, where someone said, well, this is postmarked this date, and so it's therefore this rent increase didn't give me 30 days. Have you had any of that? Just curious.
Not yet, but we had a few challenges under the this Shegian case. We
Uh-huh.
discussed it a few times, which for 3-day notices for pay and quit. Um, there's this sort of new case law created rule which says that the tenants need to know exactly when they were served. And so what a lot of process servers are doing now is they're handwriting the
Hmm.
date that
Onto
they
it.
serve the notice so
Hmm.
that the tenant can't bring that up as a challenge. But as far as the post office is concerned, no, we haven't had any challenges yet.
Okay. Yeah, so just everybody be aware of that. It's best to kind of take it into the post office and run a layup instead of sticking it outside your front door, because then the postmark date could be different, and then you kind of put yourself into no man's land. Anyone
Yeah.
want to be in no man's land? Not me. So try to stay out of no man's land. Let's try to keep these things airtight. And Britt, they can give your office a call if they have more questions.
Yes, I
Okay.
can leave our office number on chat.
Yeah, there it is. It's 510-617-0635. Is that the best number?
Yes, that's the best
Okay.
number.
Okay. And you can give them about 5 minutes. You're not going to give them 30 minutes for free, right?
Well, the way we have our consultation set up is again an hour consultation. I believe with Richard is $600, and then anything I think 15-minute consultations, even 30 minutes, those are free, so we don't
Oh,
charge for
okay.
that.
Oh,
Yeah.
wow.
What we
Okay.
do is, 15 to 30 minutes, we just basically give you a little overview of where you're at and what your options are. And
Mhm.
it's really to try to see if you need an hour consultation. And if we can't get your issue resolved within that hour, then, we might have to get retained
Yeah. Or
with the
within
company.
that shorter period of time. Yeah.
Right.
Okay. Well, great. Well, I appreciate you taking the time to put it all together. And you guys are constantly looking at our forms. I know we updated our rental agreement. There's some typos in there. We updated the plumbing agreement to make it so that the regular wear and tear stuff is not in there. The checklist got updated. Again, this maximum allowable rent increase thing just dropped. So we have a bunch of updated forms, and we're going to continue to keep everything up to date. And so, Prit, thank you for being part of a team, your office being part of a team. And then we have a couple different attorneys in LA. We have one in San Diego. So we're really trying to cover the state. And when we have different offices with different looks at everything, it really helps us come up with forms that are um, thorough. And I'm just so thankful that we have that, that you guys are contributing like that. So we're really thank you for you. Okay,
Absolutely.
Oh, so Prince numbers again. Oh, Prit's number again. Yeah. So if you're in this, you don't see it because it's on YouTube. It's 510-617-0635. 0635. It's 510-617-0635. And anyway, so Beckman, Feller, and Chang, boom, there you put it in. Awesome. And hopefully we'll see you guys sometime soon. Take care, everyone.
Thank you guys. Appreciate it, Jeff. Bye.
Thanks.